clearly. Okay. Now, since I think we've been drawing parallels with Arbitration Act, Varun, since beginning, I think it will be very, very apt, and I think it may be a question in the minds of other people as well, the audience, that if you could articulate the key differences between an arbitration and a mediation, since there are quite a few similarities as well. Both are alternate dispute resolution mechanisms. So, what are the essential differences between an arbitration and a mediation?
Okay. First and foremost, the terms itself, the arbitrator and the mediator. A mediator basically acts as a facilitator to resolving the disputes. However, an arbitrator is more of an adjudicator of the issue. The mediator will not necessarily go into the merits of a case. However, the arbitrator will specifically go into the merits of the case, will go through the evidences, will go through the documents. The mediator will not do that. So mediation is more of we can draw the same attention. It's more of a little informal structure wherein the parties are only sitting and the mediator is facilitating for settlement of the win-win scenario, settlement of the issue. However, as for the arbitration is concerned, arbitration is where one party wins and one party loses, because it's nothing but it's a concept of court only, where a judge or the arbitrator having the authority of being the adjudicator, the judge who judges the complete scenario on merits and then passes an order. However, in mediation, it will be a win-win situation for both the parties. The mediator will facilitate the mediation, will push the parties to reach an amicable solution, reach an amicable solution, and then get the mediated settlement agreement drafted.
Right. No, absolutely. Varun, but if somebody has to facilitate a settlement, as lawyers, even as litigating lawyers, one of their jobs is, of course, to initiate settlements, to negotiate settlements, etc., even while they are litigating. And I think one of the good results which comes out of a litigation also is a settlement, which is a win-win, which is a win-win. So while the case is going on, then nothing stops the parties or the litigation counsels to sort of talk, sit together, and negotiate a settlement agreement. So if all that can anyways be done in an informal context, settlement agreements can be drawn and agreed, then why this act is required? I go back to the first question, why this act is required? I mean, settlements is not a new concept, and are we teaching, how to settle to the lawyers or what?
So, Sumit, if I understand it correctly, you're basically asking me what is the difference between a regular settlement agreement and a mediated settlement agreement?
Maybe that's what I want to ask. Yeah.
Okay. So a regular settlement agreement is a contract. When the parties, if it's not under this act, if it's a regular settlement agreement, the parties who have now reached a settlement, they sign a contract, and that they sign an agreement that becomes a contract. However, as far as the mediated settlement agreement is concerned, under the Mediation Act 2023, mediation settlement agreement will be a judgment. So it will no longer be something where if someone wants to oppose or challenge the settlement, it will go back to the merits of the case. No. So for an agreement under the Mediation Act 2023, a mediated settlement agreement will be treated as a judgment passed by the mediator.
Right.
And the same can be again enforced through the same provisions of CPC as in arbitration.
Right. That's interesting. So what you're saying is that in case of a normal settlement agreement, historically, when parties were litigating and lawyers were negotiating settlements, and they draw up a settlement agreement on stamp paper, notarized, this, that, if that breaches, if the consent terms or a settlement agreement breaches, you would have to approach the civil courts or whichever court of jurisdiction.
Correct.
For breach of that contract, right? Breach of settlement agreement or contract. However, in this case, you are saying that in case of a mediated settlement agreement under the Mediation Act, it will be as good as a decree. Once the settlement agreement is reached, it will be as good as a decree. And therefore, if there is a breach, then you'll have to go for execution, probably, right?
Yes.
As an execution proceeding.
Yes. So with the regular settlement agreement, parties go back to litigating. With the mediated settlement agreement, parties will go for execution.
Right.
Yes, and as far as the challenge is concerned, there is a specific section which talks about challenge of the mediated settlement agreement also, but it's very, very limited. It's very limited to fraud, corruption, or undue influence, and if the matter that was basically mediated forms part of the first schedule under Section 6 that we just discussed previously.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
So it's a very limited grounds for challenge also. So for a mediated settlement agreement, it won't be further litigation. It will be execution only.
Right. No, wonderfully articulated the difference, I think. And also, Varun, the Arbitration and Conciliation Act has been there. And while, of course, it has been doing a good job for arbitrations, the conciliation as a concept or as a matter has not really been so used, or at least it has, at least in my own experience, I haven't really seen too many conciliations under the Arbitration and Conciliation Act per se. So if you could articulate the difference between now the Mediation Act and the conciliation of the Arbitration and Conciliation.
Okay. Sumit, I would say mediation is a kin of conciliation only. So as for the Arbitration and Conciliation Act, conciliations definitely, even very few people actually go for conciliation under Arbitration and Conciliation Act. But with the coming in force of Mediation Act 2023, as a part of the original act that has now been released, the conciliation sections from the Arbitration and Conciliation Act have been amended. So have been removed. So the conciliation there is nothing but mediation here.
Right. So I think by virtue of an amendment in the other acts, in the schedules, the entire conciliation chapter has been removed, right?
Yes. Section 61 to 81, if I'm not wrong, but yes.
Yeah, I think it's time for the legislature to now renomenclate the Arbitration and Conciliation Act to Arbitration Act only, because conciliation has been taken care of. The name of conciliation has changed to mediation, is what you're saying. Right. Yeah, there may be a very, very thin line, I think, difference between conciliation and mediation, but I think for all practical purposes, this is what it is now, mediation.
I can also explain that thin line, maybe what you are referring to.
Yeah.
See, for conciliation, a conciliator sits and doesn't facilitate the complete settlement process. The conciliator will sit and the parties will then decide, and if they decide on reaching an amicable solution, then the conciliation is a successful conciliation. As far as the mediator is concerned, mediator pushes the parties to actually resolve the issues. So conciliator and mediator, this is the difference.
Yeah, although, it's slightly, counterintuitive also. Means if a conciliator sits and does not do anything, then why does he sit in the first place, on a lighter note. So I think good that conciliation has gone with that thin line difference, and mediation, which is more progressive, more proactive, where the mediator is supposed to be negotiating mediations, and nudging the parties to mediate. I think that's what is the essence, and I think the essence of this act, other than the ad hoc mediation or the mediation as a concept, one of the key things to me when I was reading it is the institutional mediation concept, which was not there at all. There was nothing called institutional conciliation, right? To the best of my knowledge. But now there is institutional mediation and a whole ecosystem of mediation service providers, mediators to be registered with the Mediation Council of India, Mediation Council of India as a body, to have its chairman and executive body and, etc., under the government. So I think this is quite a welcome step to promote the whole concept of mediation, which is quite welcome. I just share, Varun, one of my experience. I was appearing in one of the district courts, and the matter was referred to the mediation center in that court with the consent of course, both the parties. And as you had said, they are not interested in the merits of the case at all. I mean, they don't even get into it. Their question is how much you are asking for and how much you are wanting to give, and why don't you just settle? Means I think the mediation happened so quickly because with the just the presence of a third party who is unbiased and who doesn't have any vested interest or no conflict of interest, and I think who nudges you, to sort of negotiate, to bend a little bit here and bend a little bit there. Mediations can be sort of forged.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.